Today I want to talk about how incapacity affects your ability to even file for divorce. Hello, my name is Megone Trewick, lead estate planning and guardianship attorney here at the law office of Bryan, Fagan. Before we can enter into whether you can file for divorce, we have to talk about the level of your incapacity and who is actually incapacitated. If it's the spouse that's not incapacitated, that's seeking a divorce, then the question is, can he or she move forward with the filing? Well, Texas law does allow you to file for divorce even if your partner is incapacitated. For many of us, the incapacitation is a mental illness. In Texas, we have no-fault divorce and we have at-fault divorce. One of the at-fault reasons that you can seek a divorce is if your spouse is mentally ill, has been in an institution for 3 years or more, and the prognosis of his or her recovery is dim. So they have really a permanent incapacity. That qualifies for an at-fault divorce in the state of Texas. Therefore, he or she can file for the divorce, get their divorce. Yes, the incapacitated spouse would get a guardian or an attorney ad litem who would stand in place for them and move forward with making the necessary negotiations. However, what if it's the incapacitated spouse that wants a divorce? How does that incapacitation affect their ability to even file for that divorce? And will the spouse that's not incapacitated prevent or try to block the divorce? Those are the relevant questions in a situation like this. So if you have a person who is incapacitated mentally, who has been found to be incapacitated, who has a guardian, and then that person is seeking for divorce, things become a little bit tricky. In that situation, if they don't have the capacity to even understand the extent of a divorce or understand what exactly a divorce is, then you have to pass a couple of benchmarks before a divorce would even be allowed. And believe it or not, in a situation like that, you would be in probate court and not in family court. So if you have a person who is incapacitated and they are convinced that they must get a divorce, first you have to have the guardian or the attorney ad litem. That's going to be the person who will be moving forward for the filing of that divorce. But there are still thresholds they have to meet. Is this divorce in the person's best interest? And is this really what this person wants? If you have a situation wherein the person is incapacitated, has a guardianship, and the guardian believes that this divorce is in their ward's best interest, they're going to have to go to a court and try to convince the judge that it's not that guardian who wants a divorce and it's actually the ward. And the second threshold is they have to prove that it's in the ward's best interest. It's highly unlikely that that guardian will pass that really tremendous benchmark that they have to pass. And therefore you find where somebody's in a guardianship, it is very hard to get that divorce. However, all situations are unique, and therefore you need to speak to a guardianship attorney who actually knows how to maneuver around a guardian who needs or wants a divorce. My name is Megone Trewick, lead estate planning and guardianship attorney here at the law office of Bryan Fagan, and I would like to talk to you about your unique situation. Please like this video, go to Facebook, you can see us there, we're also on YouTube. Thank you very much.